SJC-13494 in the matter of a juvenile.
Okay, Attorney Messer.
Good morning. May it please the court, Dawn Messer on behalf of the appellant child who is in the custody of his fit father.
Could you speak a little louder?
Yes, sorry. In care and protection cases, when the custodial parent is unfit, the juvenile court has the power under Chapter 119, Section 26, to adjudicate the child in need of care and protection and transfer custody of the child to the fit, previously non-custodial parent. That's what the court did in this case with this father. When that happens, the juvenile court's role as a court of protection is complete, and the care and protection case should close.
I understand your well-reasoned arguments for finality in the constitutional rights. And I think the juvenile court would appreciate getting these cases off their docket.
Yes.
But can you tell me, in the parade of horribles, what could happen thereafter in the probate court under the statute that would upset this?
That would upset the
Custody findings and the like. What's the potential harm that could happen that would guard against in the probate court?
So if the juvenile court was allowed to close the care and protection case with the custody order to the fit parent remaining in place, then the next step would be, if there was a substantial change in circumstances, then either parent can file a complaint for modification in the probate and family court, and the judge in that case could review the change of circumstances and then determine what is in the best interest of the child at that point. It wouldn't be a protective case. And I can understand if this court would be concerned about the safety of the child when the case closes in the juvenile court, but that's not a risk anymore once the child is with the fit parent.
I'm
Sorry, so, again, I'm relying on recollection. There's a difference. Permanency is not really permanency. It's dispensing with consent to adoption is sort of the irrevocable act in this world, right?
Yes.
Does the juvenile court have the ability to dispense with consent to adoption? Do they have the same powers that the probate court does in that regard?
Yes. They didn't originally, but they do now. So in 1992, Chapter 119 was amended to allow the juvenile courts to dispense with consent to adoption. So they really have the power to do.
So they have the same powers. It's not like the probate court has any power that the juvenile court doesn't have?
No, but they're a different focus, right? The juvenile court is a court of protection, and the probate and family court hears everything else.
Right, but when we've been talking about permanency, that's a little misleading in this world because it's still a revocable act. Dispensing with consent to adoption ends everything. We enter a new world. The parents are completely out of it. But you want us to sort of take an additional step on this based on a permanency finding, right?
So,
and again, if I'm taking you far afield, you stop me, but that's what caught me as being odd here.
No, and I understand how the court would be hesitant to take a step that doesn't appear or that the court is worried isn't called for in the statute, but it actually is. In Section 26, that was amended in 2008 to allow the juvenile courts to transfer permanent custody to a parent, including a previously non-custodial parent. So that is called for in the statute. What is not addressed in Section 26 is how the case ends after that transfer of custody.
But my question was a little different, which is that a transfer of permanent custody, although it sounds permanent to us, isn't really the terminology in this world. Dispensing with consent to adoption is the parents are then permanently cut off. Somebody that's not what we're dealing with here, right?
Right.
So the case is still alive, but you want us to engage in an irrevocable act, right? You want to basically cut the mother off.
No, so that's not what we're asking to do.
Okay.
We're just asking that the juvenile court case, which is the protective case, that ends. The mother still has every right to go back to the probate court if there's been a substantial change in circumstances and change that order. So it's not.
Is that under 209C, Section 3?
So
The Section 3E argument, how does that interplay with the finality? Could you address that, please?
So, sure. So the first, to answer your question, Chapter 209C, Section 20 is the complaint for modification portion.
I'm not talking about modification, I'm talking about Section 3, the
So-
child out of wedlock statute.
Right, so 209C, Section 3 is the one that talks about among other things, the juvenile court's concurrent authority to issue paternity judgments and child support orders. That doesn't speak to custody transfers to previously non-custodial parents through the juvenile court. It's a completely different question.
The DCF argument that I read was that custody could revert to the mother based upon application of 209C, Section 3E in the probate court. Is that a fair
So-
assessment?
No, that's not a fair assessment because 209C, Section 3 deals with paternity and custody jurisdiction of the juvenile court. It does, I'm sorry, paternity and child support. It doesn't deal with custody, which falls under Chapter 119, Section 26. That's where the juvenile court's authority to issue permanent custody orders to a previously non-custodial fit parent comes from.
Can you go back and finish explaining what happens when there's a change of circumstances and the mother can then do something? What she can?
So the mother could file a complaint for modification in the probate and family court, just like all other parents who want to change or modify an order. She can file a complaint for modification in the probate and family court. It's under 209C, but it's Section 20. And then she would have to show that there's been a substantial change in circumstances, and now she wants either the custody order or the parenting time agreement, whatever it might be. She wants that modified, and that's based on the best interest of the child. So she doesn't lose her rights, her parental rights to the child. She's still in the same position as all other parents in the probate and family court to litigate those issues.
So what is it that the child and the father get by closing it in the juvenile court? What do they get out of it?
They get an end to intrusive state intervention and judicial oversight. It's a substantive due process issue. If this is a fit father and a child in the custody of his fit father, his father is presumed to make decisions that are in his best interest, and as this court noted in Blixt, those aren't reviewable by a court unless they're harmful to the child. So the care and protection case is a protective case. It's not supposed to be long and enduring. Once the need for the child's protection ends, that case should close.
So can I ask you now what happens? So it takes a while, I take it, in the probate court. So as these determinations are made of fitness, the cases are reviewed every 6 months or so in the juvenile court?
So they can be. There's a right to review and redetermination while the case stays open. That doesn't say that the case has to stay open.
So practically speaking, what happens in these cases?
If the case remains open
Yeah.
and there's a permanent custody order to a parent, a fit parent.
Right, and then there's a woman, or could be, because the judge, a very conscientious judge here, said, I can't close it because of the interplay between the probate statute. So what
Yes.
happens to those cases?
While they're waiting for probate and family court action.
Yes.
The parents, all the litigants are still under the scope of the juvenile court, the protective court. The parties may be brought in at any time based on either the court wanting them to come in or any party advancing the case for a status hearing. At the same time, the Department of Children and Families, their policies don't allow them to close their protective case until the juvenile court case is closed or dismissed. So there are social workers that have to come into the home and meet regularly with the family, check on collaterals of the family, ask intrusive questions of the parent and the child, and there are court-appointed attorneys that are assigned to these cases. All the parties have a right to an attorney, so the attorneys also have to go into the home and question the parents and question the child.
So for
all of these are intrusive actions.
Practical purposes, it does, if the child's with a fit parent, they're not going to be brought in, practically speaking, they're not going to be brought in for questioning, but a social worker will come. I mean, that's something they have to do if it's open with DCF, is that it?
Yes, and as this court recognized in Millis, just having an open case is harmful to the child and the parent-child relationship. So this child is 12 years old. He knows that his father has this looming case or had this looming case over him. He knows that he was brought into court multiple times after he had custody of this child, and he knows that that's stressful, and that causes him stress and anxiety. So just because he's not brought into court doesn't mean it's not harmful to him.
But the substantive due process issue is the fit father who's being put through this.
Correct. Well, the fit father and the child along with him has a substantive due process right to family integrity.
And when there's a dismissal in the juvenile court, does that mean that the determination that the mother is not fit is no longer in place?
No, so this would be, we use these terms interchangeably sometimes, dismissal and closure. We're not talking about a dismissal pretrial for failure to state a pleading or failure to state a claim or for a jurisdictional issue. We're talking about closure of a case after a judgment. So what the child argues is that once that final judgment enters, the case can close and the order will stay in place until another judge looks at it and changes it for substantial change in circumstances. The order is what's important. That order should persist.
But I can't, I'm not sure
Sorry.
Go ahead.
The order in this case is that the father is awarded permanent custody with some agreement as to parenting time. That's the final order?
Yes.
And so that agreement as to the parenting time would still be, enforceable, or the father would need to abide by that
Correct.
if the case was closed.
That's correct, and that's what happened. Eventually, it took 2 years from the time that the juvenile court asked the probate court to take action, but finally in October of last year, the probate court did take action. The juvenile court case was dismissed in October. I'm sorry, the probate court took action in August. The case was dismissed in October with those orders in place. But it was the probate and family court issued the order and adopted the agreement of the parties. So that was the end of this case. But what we're saying is that step didn't even need to happen. The juvenile court could have closed their case without the probate and family court even acting. The
Now
juvenile
that the
court
probate
could,
and family court has acted, you're suggesting we nonetheless decide this case even though it is moot.
yes, because this happens often in the juvenile courts and it clogs up juvenile court dockets. You can see the frustration of the trial judge in this case, talking about how these cases take up valuable judicial resources and social worker time and attorneys that are court-appointed that really need to be focusing on families who do need the intervention and the judicial oversight. So this is not just it's more than the substantive due process rights of the family, which is the primary concern. It's also a judicial economy issue, and these juvenile courts are buried under the caseload.
And counsel, isn't this just an economy issue as well? I mean,
Yes.
that you have to go to probate and family court, and a lot of times the parent isn't of means to be able to go out and prosecute this.
That's correct. It's very difficult for parents to navigate that system. Sometimes it's difficult for us attorneys to navigate the system. As a trial attorney, I know sometimes you don't fill out the right paperwork, or you forget to include a certain form. These are unrepresented litigants who have to navigate the system, in addition to the volume of cases in the probate and family court
But
that they have to go through.
DCF says that it's not possible because of the statute, right?
That is the argument.
And so what is it that, is there something we would have to read into the statute in order to do what you want us to do?
So when a statute like Section 26 is unclear and it implicates due process rights, this court can clarify and interpret its terms in order to satisfy due process. So what we're asking this court to do
Some
is...
substantive due process magic.
Sorry?
What's some substantive due process magic? at
Yes,
this statute?
exactly. And it's really not complicated what we're asking the court to do. It's simply to clarify that once a juvenile court judge grants permanent custody to a fit, previously non-custodial parent, that case, the care and protection case, can close, and that order that the juvenile court judge made will stay in place.
Substantive due process, though, is designed to deal with really bad stuff, right? And one thing I have a little trouble following is what, because this isn't a dispensing with consent to adoption case, so there's still an ongoing concern. You know, the mother still is in the picture here.
Yes.
And this I'm just trying to, the practical effect of not doing this, it seems difficult to say that this is a substantive due process violation, because, again, the mother isn't out of the picture. This father and this child don't have assurances that the mother is her. She's still a player here.
Right.
Regardless of whether we do what you want. I just can't understand exactly the difference. And we've got a fit father and an active C&P case versus a closed C&P case. I have trouble understanding that's a substantive due process problem.
And I understand, but I understand your concern that the mother is still involved. That is as long as the mother has her parental rights, she should be still involved.
No,
The
I'm not
difference
questioning
is-
the continued involvement of the mother. What I'm trying to figure out is why the father and the child have why there's a substantive due process problem for the father and the child without this, in Justice Gaziano's word, magic, substantive due process magic, because the difference in their worlds, whether this happens or not, is not that big as far as I can tell. But go ahead, tell me why I'm wrong.
Yeah, it's actually huge. The difference is the state is involved in their life and overseeing their every action, and that is the difference.
Really true?
That-
When you've got a fit father who's been given a custody order under the C&P, because she's going to get up and tell me that it's not, the sky is not going to fall. I just want to give you a chance to tell me why the sky is going to fall again.
So this court has recognized in Millis and
Millis is a Chin
Blixt.
case, right?
Millis is a CRA case, and
It's different.
not necessarily, because it talks about the stress and anxiety caused to the child and to the damage to the parent-child relationship simply by having ongoing unnecessary judicial involvement. And that's really what this is about, is that, and in Blix the same thing, and in Rashida, the court talked about the trauma that these families are suffering while under the specter of the juvenile court and these protective cases, and how the trauma is, it is exacerbated the longer the case takes to resolve. So the difference between having it in the probate and family court between mom and dad is that the state is no longer there in the picture the family is no longer under the microscope of the state and under the juvenile court purview, right? So the stress of the litigation is gone. And because this is a protective court and the father who is fit and the child in the father's custody had this substantive due process right to be free from unnecessary state intervention and judicial oversight, that harm is what exists when you keep a care and protection case open long after it should have been closed.
Any other questions? Okay,
If there are no further questions, I'll rest on my brief. Thank you.
Okay, Attorney Kernan.
May it please the court. Jennifer Kernan for the Department of Children and Families.
Are you going to explain to us what DCF's, what DCF's interest is in maintaining the status quo?
Yes, if I could just clarify what Your Honor is referring to in terms of the status quo. Generally, the current process?
Right.
Okay, all right. So the department's position is not that what child's proposing should not happen, just that under the current state of the law, it cannot happen.
So you would be fine with it, say if we did some substantive due process magic and decided that that's how it should work, DCF would have no problem with that?
Essentially. Our concern...
What in Section 26 precludes this outcome,
So-
even without the magic?
Even without the magic, Section 119.26 sort of requires the judge to act in the best interests of the child. And here, when considering child's motion to dismiss in the trial court, the court determined that because she didn't have the authority, or because she thought she didn't have the authority to do so, that it was in child's best interest not to dismiss that case. And part of that was her concern that upon dismissal, her order of custody to the fit father would no longer be viable.
But if what in 26 says that her order of permanent custody to the fit father would no longer be enforceable?
There's nothing in 119.26 that says it either way.
Right.
And that's part of why we're here. It's unclear at the moment. And I think both sides are hoping that we'll have some clarity from this.
Is the concern that under the unwed parent statute, under Section 3E, the mother would have custody if the mother goes to probate court?
Yes, but not exactly. So,
Okay, please tell me how 3E
right, and so I
figures into this.
think Your Honor might be referencing 209C10. 10 is and I could also be totally wrong, but 10, I believe, is the statute that defines custody remaining or lying with the mother when a child is born out of wedlock. And that's sort of the crux of the concern here, because if...
But counsel, I don't mean to
I'm
interrupt
sorry,
you,
could we
but
just could get the answer? I'm confused on this.
well, I just want to make certain, the provision we're talking about, so doesn't that mention if there's no paternity designation?
I think I can answer both.
Yeah, please.
At least I'm going to try to. All right. So, talking about 209C10, Your Honor is correct. Well, it is not correct. I'm sorry. It does say that even after a paternity adjudication, in absence of an order otherwise, and here the C&P, the Care and Protection Order, is that order otherwise. And if that order otherwise were to go away, such as the department is arguing that if the case were dismissed, it would go away, then we're left with 209C10, which says, even after an adjudication of paternity, without another order from probate court, custody lies with the mother when parents were unwed and the child was born out.
That couldn't happen constitutionally because the father can't have less rights because the child was born not during a marriage. So it can't happen.
It's And I'm actually
I know it's hard for the juvenile court judge to do this. She saw the issue, she's a
Right.
very conscientious judge. But you just can't have a dad, because his child was born not during a marriage, have different rights than other fathers.
Yeah, and that was one of the concerns that the juvenile court judge did raise. But it's, I was just going to say, it's a tricky one to answer here. I think that if we look narrowly at this issue, as opposed to broadening the scope and bringing in equal protection and gender, we can still resolve the more narrow issue here. And one important point here is the distinction between dismissing the care and protection case and closing the case. The department agreed, and I'm going to use the term close to mean render the case inactive, similar to what the probate court does after a judgment in a divorce. So for example, and I'm no probate practitioner, but my understanding is that after there's been a judgment for divorce and there's any attenuated custody orders or visitation orders like that, the case sits inactive on the docket. There are no further dates unless a party files a complaint for modification of custody. And I think here in the juvenile court, and this is sort of the informal practice in some of the courts, that once there's been an order to fit parent, like in the situation we have here, we've got a fit dad, the juvenile court judge will instruct or suggest that the previously non-custodial fit parent should go to probate to get that other order. And while that's happening, the C&P will sit inactive on the docket. There'll be no further dates unless a party chooses to exercise their right to review and redetermination, which can only happen once every 6 months. And generally, when there is custody to a fit parent, it's highly unlikely that the department would seek to utilize their right to review.
Is there any danger upon the dismissal or closure of the C&P case that custody could revert to the mother in this case?
So yes and no, because dismissal and closure are different.
Right.
On dismissal, yes. And the department's position is that because of the interplay of the statute, specifically 209C10, without the C&P's order of custody to father, there's no other custody order which would prevent or keep custody with father per 209C10.
Why would?
But closure would be different.
Closure would be different.
But she
Why
wanted to
would
close it.
Why would dismissal result in vacating the prior order to the father? That's where I don't understand.
So essentially, there's nothing that expressly states that a custody order or any order stemming from a care and protection would survive after dismissal. There is 11928, which is the same language as 209C3E that talks about the custody or the support judgment surviving for 6 months after the dismissal of the care and protection. So in that instance, in 11928, we have that express statement of these types of orders survive. There's nothing like that with regards to a custody order. Additionally, the appeals court has dealt with a couple cases that are kind of similar, and that's Joselito and Yarrick. And the sort of extrapolating from those cases, it would seem that any order, the finding of fitness, order of custody, would not survive dismissal. So those are sort of the two reasons.
Substantive due process magic dust doesn't have to be applied. You think we can do this by interpretation of statutes?
Again, yes and no. With dismissal, no.
How come every time I ask a question,
I know,
it's yes
I
and
know.
no?
I know, I'm sorry. I'll try to.
It's me, not you.
With closure, I think it's possible with closure. And again, closure meaning inactive.
Yeah, but here's what I think the child is saying. I think they're saying that with dismissal, as a matter of constitutional law, that the father's custody order has to remain in effect. It just has to be. Why? You got the best interest of the child, which is, I realize, statutory, but you've got an order, and you can't have the case be maintained and have to have the state in your house, figuratively or literally, when the social worker comes by, as a matter of substantive due process. And so the only way for the statute to be constitutional would be that the juvenile court's order of custody of the father remain. I think that's what their position would be. What's wrong with that?
There's nothing wrong with that, except for the fact that we don't have that on the table yet. I think action from this court to that effect would be fine.
That's what Justice Garcia means by the substantive due process. Does.
Yes,
But
yes.
do you agree it's that intrusive? I thought you said
No.
the opposite.
No.
It's basically, this is, I mean, these people have a lot to do, both, and when this thing is really inactive, nothing really happens. I mean, she's saying the opposite. I just don't know you know this better than I do. What is the answer? Is there really, I mean, substance due process is like, we're beating you with a stick kind of stuff. This is like, I can see trying to make magic out of the statute, trying to use this to argue that there's a substantive due process violation here unless you lose custody. I get that might be different, but if all it is you've got the state possibility of and by the way, no way, they got tons of real things to do. So that just doesn't seem like the substantive due process violation to me. I'd love if you can make the statute go away, because it sounds like you want us to reach that result. But for us, substantive due process is a club we only bring out every once in a while to deal with serious problems. And the fact that you might have to go to the district court once every 6 months doesn't seem to me like a substantive due process violation.
Yes, I think Child and I disagree on the extent of the involvement or intervention.
Right.
And so I'd like to answer Your Honor's question in two parts. First, with regards to what extent is DCF really going to be involved? If the case is made inactive, DCF can close its clinical case, meaning that there'd be no social worker home visits, no action plan, no required meetings. And an inactive case also necessarily means less involvement in court. The second part of my answer is going back to Child's reference to Blixt. Child used that to sort of talk about the burden or the attendant burden of litigation in a domestic relations case. And in Blixt, this court's solution to addressing that was to, and this was a grandparent visitation case, was to require the grandparents to make an initial showing that they would be able to meet their burden before requiring the parents to subject themselves to the court there. So the substantive due process rights, to an extent, have been addressed by the requirement that the state prove its case by clear and convincing.
I'm thoroughly confused by this at this point. So it sounds like you both agree on a result. How should we interpret this from DCF's perspective to allow this to happen without it being a substantive due process violation? Tell us, what should we write to make this silly case go away?
I feel a lot of pressure here because I think a lot of the courts are going to be interested in what comes from this case, because this is.
You are our expert. We need your help. None of us are probate lawyers either. So give us how to make this go away with a statute rather than finding some kind of imaginary constitutional violation here.
So I think the easiest solution here is to provide guidance that allows the courts to render these cases inactive. So once we've got a disposition like this, custody to a fit father, and there's no underlying probate court order, making the case inactive, letting it stay on the docket with no events, nothing scheduled.
And what statutory provision will allow us to make it inactive? Tell us, we need your help here, because otherwise
Yes.
we're going to go back and we've got other things to do. So tell us how to fix this.
So I think 11926 is going to be the basis for whatever action comes from this. Generally, 119 requires the court to act in the best interest of the child. And here, 11926 allows the court, in furtherance of the child's best interest, to make whatever orders it can, as long as they serve the child's best interest. And here, that's what happened with the court determining that child's best interest would be served with custody of father. I think that continuing on the line of assessing child's best interest here, the court could use that as a basis to say that the practice, and if I may continue to finish this answer, the practice of rendering the case off-listed, making it inactive, would preserve child's best interest in that it would prevent the custody order to the fit parent, to father here, from being vacated, which is what would happen under the current state of the law if the case were dismissed.
Well, we don't know that yet, but it seems like we're going through a lot of machinations for something that seems a little bit more straightforward. This is a protection case, right? So if it's a protection case and there's no longer a need for protection, and there's an order of the court giving the fit parent custody, why can't we just say that there's no that the statute wouldn't make any more sense because there's no longer a need for protection, and whether it's explicitly articulated in the terms of the statute, the judge can just say my order survives the dismissal of the care and protection case.
So,
What inherent authority, what says the inherent authority of the juvenile court judge to say it's over, but my order survives in the best interest of this child?
that is a very interesting question. And the scenario that you've posed reminds me of the scenario in Care and Protection of Yerrick. And if I may be permitted to continue to
Yes,
go over
please.
it. In Care and Protection of Yerrick, their father appealed dismissal of the care and protection under which mother had been found fit and custody was given to mother. In the judge's findings and orders, the judge specifically wrote, my finding of unfitness survives the dismissal and has continuing vitality. And the appeals court said, kindly, nice try, but not quite. That's a situation that I'm thinking of is similar. Without an actual basis for the survival of the custody order following dismissal of a case, I don't think that the judge could simply by writing in, it will survive.
I thought the best interest of the child was the basis.
Yes, so the best interest is the basis. And here, because there's nothing to indicate, nothing expressed to indicate that the order would survive, that I think the court has to say that the case needs to stay open as opposed to dismissal. And I do see where Your Honor is going. I do see that. I think that without something, maybe this is the best answer. I think there would need to be something more in that instance than the best interest, something like guidance from this court saying that in this situation, it would survive. But we don't have that yet. Hopefully.
Can I just ask, because I think the counsel for the child is saying closure and dismissal are the same, but you're saying that they're different. And so I'm not sure where that's coming from. And you also talk about inactive, so
Yes, and-
inactive you equate with closure.
Yes.
And those are different from dismissal.
Yes. And when my sister was talking about dismissal, I thought I heard her mention a pretrial dismissal. And there,
No, yeah, she was differentiating between
Yeah.
something like that and something like this.
yes.
Yes.
But I think that even post-adjudication, where we are now, is dismissal post-adjudication is distinct from closing the case. Dismissal, the case goes away. There's nothing left. It's, in addition to not being active, there's no way to bring it back. There's no way to revive it. It is gone. It is done. But if it's just closed, which I'm using to mean inactive, it still lives, right? The orders that are attached to it have vitality because
Does that mean that that social workers do or don't have to come and see how things are going?
so if the case is closed, the social workers do not have to because our regs allow the department to close a case if a CNP has been dismissed or closed. So either way, the department can end its involvement. So even if
So your regulations, you said DCF regulations talk about cases being closed, but that's DCF cases, right?
So I'm sorry, I'm using that to, within our case closing policies, we've got our clinical cases, which are like our internal cases, but we also have guidance about when there's a court-involved case. And here, this particular policy is addressing court-involved cases. So when a court-involved case, like a care and protection case, is closed, made inactive, department policy allows us to close our clinical case.
And are there other examples of times when a juvenile court judge will close a case?
There are, that would happen for example, with a guardianship. And care and protection of Thomasina is a good example or a good illustration of something like that happening. After an adjudication, and in order for a guardianship, it would be likely an adjudication, child's in need of care and protection, an order of custody to the department. And then on the guardianship petition, the court would award guardianship to whoever is.
I'm confused now, though. If you close the case and there'll still have to be that 6-month review of a CNP I'm trying to address opposing counsel's concern that the state is still active. And you're saying when we close our case, the social workers don't show up, but I take it there still has to be a 6-month review of the CNP, or is that not true too?
So not necessarily. And the 6-month review, that right to review and redetermination is not an automatic happening.
Okay, it's not automatic, okay.
It has to be requested, and it can only be requested when there's been a change in circumstance. And in this situation, it's like where custody is to a fit parent and the child is there, it's unlikely the department would be seeking a review and redetermination. So it's not a matter of course. Every 6 months the case is brought in. It's when someone petitions the court to review and redetermine the needs of the child.
So basically, at the department's discretion, this fit father may or may not be hauled back into court for review and redetermination. At the mother's discretion, the fit father may be hauled back into the court for review and redetermination. And at DCF's discretion, it may or may not continue to have social workers come to the fit father's home.
Yes, but I would phrase it a little differently. Where father is fit and where there are no protective concerns, it is unlikely that the department would be seeking to challenge the order of custody.
But under either scenario, the mother, because we haven't dispensed with consent to adoption, this mother can come back, regardless, under whatever both of you propose, the mother is not out of the picture.
Correct.
If she finds a change in circumstance, she can come in, or she can come back whenever under
Can
whatever
I
we're
just
doing.
clarify, we're not talking about adoption at all, are we? Because we've got a mother and a father, a biological mother and father, and so we're just talking about, I mean, those are the child's parents.
Right, but the issue is, we're trying to figure out is how disruptive this relationship between the father and the child is by the, at least through the mother.
Yeah, I
And
think
under
that
either
Justice Winter-
scenario,
yeah,
the
I
mother
think-
can get involved.
So I might be able to shed a little more light on that. I think it would be similarly disruptive if the parents were in probate court. What Your Honor has proposed is a situation where mother wants to change the custody order to father. So whether it's in juvenile court or probate court, that would be mother going to the court alleging some change in circumstance, and the parties would be litigating it through there, and which is actually, DCF's not involved in probate cases, so if families want us out, probate is where you will likely not have to deal with us. So that would address the concerns the child has raised about the sort of the state intervention, at least on DCF's part.